Hello, my name is William Brightwell, and I'm with Brightwell Law. We're an estate planning firm that serves the Pensacola, Florida area. Often I am asked, how can I prevent one of my beneficiaries from burning through and spending all the money that they inherit? That's what I'm going to go over with you today. Your child may not be able to handle money. He or she may have a history of drug or alcohol use, reckless spending, or lack of common sense. You may not be comfortable with leaving your child's inheritance to him or her outright. The solution is a trust. You may ask, what is a trust? You can place safeguards on your child's inheritance to reduce the chance he or she will use it self-destructively. You choose the trustee. You decide when the trustee can distribute funds to your child. You decide when the trust terminates and your child receives the inheritance outright. We're going to choosing the trustee. A competent trustee is crucial. Many people choose a trusted relative or a friend. Select someone with investment experience or the judgment to choose good investment advisors. To avoid a conflict of interest, the candidate should not benefit from the trust. You want a person who is likely to survive for the term of the trust. However, you should name a successor trustee in case the original choice dies or resigns. You want to consider the relationship between the beneficiary and your candidate. Will the beneficiary be able to manipulate the trustee and wear him or her down with a constant request for money? A corporate trustee, like a bank or a trust company, will have investment expertise and will be impervious to manipulation. But your trust must have significant assets before a corporate trustee will take on the job. Let's talk about choosing a distribution scheme. You have many options, from leaving all of your distribution decisions up to your trustee to providing him or her with explicit instructions. Here are 7 of the possibilities you have. First possibility is you give the trustee complete discretion to decide when and how much to distribute from the trust. This scheme gives the trustee flexibility to deal with changing circumstances, but makes the trustee vulnerable to pressure from the beneficiary. It also protects the trust assets from the beneficiary's creditors. The second way is you give the trustee discretion to distribute income and principal according to an ascertainable standard. One often used standard instructs a trustee to distribute funds when needed for the beneficiary's health, education, maintenance, and support. The third way is you require the trustee to distribute all or a percentage of your trust income or value to the beneficiary periodically, for example, monthly. The fourth way is you require the trustee to distribute a fixed amount periodically until the trust assets are exhausted. The fifth way is you require the trustee to make distributions when the beneficiary achieves specified milestones, such as remaining drug-free or employed for a specific time. The sixth way is you allow the trustee to make distributions from specific purposes, such as the purchase of a home. The seventh way is you instruct the trustee to pay third parties directly on your child's behalf, for example, tuition to a college. This option also protects the distribution from your trustee's creditors. Now I'm going to talk about deciding when your trust terminates. You can terminate the trust when the beneficiary reaches a certain age, for example, 50. He or she receives then the remaining trust assets outright. You can terminate the trust in stages, for example, 1/3 when the beneficiary reaches 40 years old, 1/3 when the beneficiary reaches 50 years old, and the balance when he or she turns 60. You can let the trust last for the beneficiary's lifetime. And you can name another beneficiary to receive the remaining assets when the trust ends. We're also going to talk about adding a spendthrift clause. A spendthrift clause in a trust does 2 things. First, it prevents the beneficiary from signing his or her interest to the trust to someone else or borrowing against the interest. The beneficiary cannot spend any trust funds before they are distributed to him or her. Second, with some exceptions, the spendthrift clause prevents the beneficiary's creditors from reaching assets in a trust. However, funds distributed to the beneficiary from the trust are available to the beneficiary's creditors, just like any other assets owned by the beneficiary. To sum it up, a trust is an effective tool for reining in your beneficiary wants to spend all the money they inherit and all the worst impulses. It can ensure the inheritance you worked hard to provide lasts for years or even a lifetime, and is available for your child's essential needs. Brightwell Law is here to discuss your situation. You can contact us at 850-332-0003.